phone call from Brigadier Geninda, who informed them that they had to take accused number 2 to Lieutenant Colonel Rapatu at Moroga Police Station for purposes of a statement. 4. It is common cause that they were traveling in a Toyota Fortuner with registration plate FV47LRGP, which was driven by Detective Sergeant Mohane. Detective Sergeant Mabena and the accused 2 were passengers. 5. The defense assertion is to the effect that the vehicle in which accused number 2 was traveling took various detours where accused number 2 was assaulted and tortured by various police officers and later made to sign a document, Exhibit HH, on the portions that were not signed at Moroga Police Station. 6. The issue for determination is whether the state can use the AVL record of the vehicle that accused 2 was traveling in re-examination of the witness for the first time when such was not raised under cross-examination. Under paragraph B, I deal with the applicability of law to the relevant facts. I deal with the provisions of the Constitution. 7. Section 35 of the Constitution of the Republic of South Africa, Act 108 of 1996, deals with arrested, detained, and accused persons. The provisions of Section 35(3), which deals with accused persons, provides as follows. Section 35(3). Every accused person has a right to a fair trial, which includes the right, small letter B in bracket, to have adequate time and facilities to prepare a defense, small letter I in bracket, to adduce and challenge evidence. C, the provisions of the Act, paragraph 8. The time-honored sequence of our adversarial system of cross-examination in chief, cross-examination and re-examination is enshrined as far as criminal trials are concerned in Section 166(1) in bracket of the Criminal Procedure Act 51 of 1977, which reads as follows. Section 166, which deals with cross-examination and re-examination of witnesses. Subsection 1. An accused may cross-examine any witness called on behalf of the prosecution at criminal proceedings or any co-accused who testifies at criminal proceedings or any witness called on behalf of such co-accused at criminal proceedings. And the prosecutor may cross-examine any witness, including an accused, called on behalf of the defense at criminal proceedings. And the witness called at such proceedings on behalf of the prosecution may be re-examined by the prosecutor on any matter raised during cross-examination of that witness. And the witness called on behalf of the defense at such proceedings may likewise be re-examined by the accused. Close quotation. Paragraph 9. The right of a party to re-examine his or her witness is therefore a favor granted by the court. Is therefore not a favor granted by the court, but a legal right, statutory entrenched. The accused is called to testify in a criminal trial, is a witness on behalf of the defense, and is entitled to rely upon Section 166, subsection 1 in bracket. Paragraph 10. As far as the right to re-examine the witness is concerned, the operative word in Section 160, subsection 1 in bracket are of any matter raised during cross-examination of that witness. Paragraph 11. 2 points emerge from an analysis of the quoted words. Firstly, there is a statutory right to re-examine on any matter if it is raised during cross-examination. These words of very wide compass, any being a word of wide and unqualified generality. See R. versus Hugo, 1926 AD 268 at 271. Paragraph 12. Secondly, the right to re-examine a witness on any matter is only limited to the extent that it was a matter raised during cross-examination of that witness. The contextual meaning of any matter raised during cross-examination of that witness cannot lead to misunderstanding. Paragraph 13. It will result in the absurdity that if any matter were raised during cross-examination in chief and the witness were cross-examined thereon, no re-examination will be permissible. This will be a denial of a time-honored rules relating to examination of witnesses acknowledged in our courts from the inception of the adversarial system. Paragraph B, the object of re-examination. At paragraph 14, generally speaking, the object of re-examination is to, small letter A in bracket, clear up any point or a misunderstanding which may have occurred during cross-examination. Small letter B in bracket, to correct wrong impressions or false perceptions which may have been created in the course of cross-examination. Small letter C in bracket, to give the witness a fair opportunity to explain answers given by him under cross-examination, which if unexplained may create a wrong impression or be used to arrive at a false deduction. Small letter E in bracket, to put before the court a full picture and extent of facts elicited during cross-examination, or to give the witness an opportunity to correct patent mistakes made under cross-examination. 15. Re-examination can be and frequently is a very important mechanism for presenting a full and fair picture of the evidence of a witness and thus of arriving at the truth. Paragraph 16. After cross-examination has been concluded, the side that called the witness is given an opportunity to ask questions. This is done according to the rules which apply to re-examination in chief. Questions are limited to the field covered in cross-examination. Paragraph 17. If counsel wishes to deal with new matters that is not arising from the cross-examination, he requires the leave of the court. This is in nature of fresh examination in chief and gives the opposing party the right to cross-examine again. Paragraph 18. Re-examination is not limited to questions broached for the first time in cross-examination. In this regard, see State versus Ramalope, 1995, Volume 1, SA 616A at page 619 to 620H. Re-examination is a useful mechanism to place a full and fair version of the witness's evidence before court and thereby to get the truth. This was also said at State versus Ramalope at paragraph 620, at page 620, paragraph B to C. Prejudice. Paragraph 19. With regards to the test to be applied to an application to reopen, see Oosthuizen versus Stanley, 1938 AD 322 at 33, and Barclays Western Bank Limited versus Guinness, and another 1981 Volume 3 SA 91N at 95C to 96H. Paragraph 20. The consideration mentioned by the courts include the following. The reason why the evidence was not led timeously, the degree of materiality of the evidence, the possibility that it may have been shaped to relieve the pinch of the shoe, the possible prejudice on the other side, including such factors as the fact that a witness who could testify in rebuttal may no longer be available, the stage which the proceedings have reached, and the general need for finality. In this regard, see State versus Farthan, 1999, Volume 1, SACR 481 SCA, at 486, paragraph G to 487B. Conclusion. Paragraph 21. The provisions of Section 173 of the Constitution provide that the Constitutional Court, the Supreme Court of Appeal, and the High Court of South Africa each has the inherent power to protect and regulate their own process and to develop the common law, taking into account the interests of justice. Paragraph 22. The role of a judicial officer is central to a criminal trial. The competency and impartiality of a judicial officer are substantive matters which affect and determine the fairness, in bracket, or lack thereof, close bracket, of a trial. Where there is a demonstrable lack of either on the part of the judicial officer, it cannot be said that the accused had a fair trial. It is appropriate to refer to a well-known dictum of Carl Lewis, J. A. R. vs. Hepworth, 1928 AD 265 at 277, regarding the role of a judicial officer in criminal trials. And I quote, "A criminal trial is not a game, and a judge's position in a criminal trial is not merely that of an umpire to see that the rules of the game are observed by both sides. A judge is an administrator of justice. He is not merely a figurehead. He is only to direct and control the proceedings according to recognized rules of procedure, but to see that justice is done." My Lord, simply, there are two issues that I have raised in my heads of argument.
Yes.
One is that if the state intends to re-examine the witness, Sergeant Mukhane, on the document, it has to seek leave from the court. Seek leave from the court to open the re-examination. Secondly, if it decides to call Sergeant Mukhane later in the evidence, it has to show that the evidence, why the evidence was not led timelessly, the degree of materiality of the evidence, the possibility that it may have been shaped to relieve the pinch of a shoe, the possible prejudice to the other side, including such factors as the fact that a witness who could testify in rebuttal may no longer be available, the stage which the proceedings have reached, and the general need for finality. Those are my submissions.
Okay. Any response, Mr. Baloyi? Oh, sorry, Mr. Nxumalo.
Thank you, my Lord. I've got no submissions, my Lord.
Okay, thank you. Sorry about that. I didn't see your head. Yes, any response?
As a court, please, my Lord, we just wish to respond to two issues raised by counsel for accused number 1 and 2.
Yes.
Firstly, he contended that the AVL report should have been disclosed right at the outset when the rest of the statements were disclosed. My Lord, the version of the accused was only put during the trial, within the trial. Before the matter is enrolled, we only sit with confessions and pointings out. We don't know what the version of the accused is going to be. We don't know whether there's going to be a trial within a trial. So the state only became aware of what the version of the accused is during the trial within a trial. The second point relates to expect evidence, and this is stated in page I think it's page 3. In conclusion, Advocate Nxumalo makes the point that if an expert witness can be called, there is no likelihood to assist the court in drawing inferences or reasonable conclusion on the face of the produced or discovered copies of the AVL, or well, I suppose the inclusion of dental reports was a mistake, as we're only dealing with the AVL. Fact of the matter is, Sergeant Mukhane is here. He's able to comment on the AVL reports, and Advocate Nxumalo on page 2 of his heads made the point on expert evidence, its role, and how it should be approached. And My Lord, in this instance, one wonders whether one can regard AVL as expert evidence in the traditional sense of the words, because these are just a report on the movement of a vehicle. It is, as it were, a fly against the wall that monitors the geographical location of a vehicle. We've indicated what the nature of a statement will be from the company that installs the device. So, my Lord, it's just merely a report that helps to determine where a vehicle was at a particular point in time. And as we've indicated, my Lord, Sergeant Mokhane was the driver of the vehicle. He's able to tell this court as to which route they traveled. This AVL report is merely supplementary to indicate whether the evidence of Sergeant Mokhane is correct or not. Thank you very much.
Thanks. What's your time there?
11:35.
Hello?